I'm actually going to talk a little broader than the president's new plan. And what I want to talk to you about is new legal issues that you should be aware of and that are coming up. I will focus on the president's plan, but I want to mention a couple of other things. Basically, I want to remind you that there's a lot going on. I want to talk a little bit about which constitutional issues we need to worry about. And as of today, there's a new constitutional issues we should be very worried about. And talk about the federal plan a bit and say two things about where the issues might come up for the school mandates. So to remind you, there's been a lot of action on requiring vaccine in the last few weeks. We've seen the Federal Government Act. To remind you, the plan had multiple things that weren't vaccine requirements. And I think the time off to vaccinate and the support for small business are just as important or more. So we want to keep an eye. But for our purposes, you're probably going to have to respond and deal with questions about vaccine requirements. And I want to remind you that there are basically three different mandates in the plan. One, a move from a mandate to federal employees from vaccinate or test to vaccinate or you're fired unless you have a legitimate exemption, a religious or medical. Two, a mandate, and OSHA is going to pass an emergency temporary standard that requires private business with over 100 employees to implement a vaccinate or test plan. And three, the Center for Medicaid and Medicare is going to require hospitals that get funding from them or other healthcare facilities that get funding to impose a vaccine mandates. Also to remind you, we have a number of states that have imposed different kind of vaccine mandates, at least two that I know of, that's Maine and New York without a religious exemption, and I'll go back to that. And we have two districts in California that imposed a school vaccine mandate for 12 and up, and we have a lot of private businesses imposing different mandates. And where states have already announced that they're going to do, and we'll probably see some business too, although my impression is that most businesses are on board or supportive and that this gives cover to a lot of business. Private individuals are going to sue, and we can expect some nonprofits. In fact, we're already seeing it from some conservative nonprofit, such as the one that call themselves With the Patriots or the American Frontline Doctors. So that's what we're going to see. What are the claims going to be? What do you need to know? I'm less worried about general liberty claims under a constitutional law. And that's because the standard that's going to use for general this interferes with my liberty is going to almost certainly be Jacobson, the 1905 case that allows the government to impose reasonable restriction on individual rights. Jacobson is a highly differential standard, and during the COVID-19 pandemic has been mostly applied in a highly differential manner. So my assessment is that claims that this violates liberty are likely not to go very far, and these mandates and requirements are likely to survive under them. What you really need to be worried about is if the federal government tries to follow New York and Maine and remove religious exemption. There are already lawsuits against Maine and several against New York on religious exemption. And this morning, a judge in New York granted a temporary restraining order on a New York lawsuit enjoining New York from refusing to accept religious exemption or denying or taking religious exemption from people who already have them. That doesn't tell us how the case will be decided, but with our current Supreme Court, we need to be worried since it's already signaled it's going to tighten protection of religious freedom. And I think the immunization community should seriously get moving and think about an amicus curiae in these cases that expresses our support of vaccine mandates without religious exemption, based on the fact that most religions don't prohibit vaccine, that any connection to cell lines is very, very remote, that religious exemption are rife with abuse and hard to implement, and that when your conduct affects other people, we have limited religion in the past. At least courts should be deferential to public health judgment on this. So worry about freedom of religion, and we really should consider acting on it. Where is it going? Where are federal mandates going to be challenged up more? So there's a number of potential constitutional claims against the federal government that aren't right claims, that are structural. I'll say something about them shortly, but I won't spend much time because I think those aren't very strong either. The federal government is a government of limited power. Most of its public health actions has been done under the Commerce Clause, the Spending Clause, or the Taxing Clause. The Commerce Clause has been used until 1995 to impose very broad rules in different varieties, but from 1995 and on, the Supreme Court tightened protection, tightened the scope of the Commerce Clause and said that if you can't really use this Commerce Clause to impose policies that aren't about interstate commerce and don't have an economic aspect. That's a very simplified description, but we can expect challenges that say this is beyond the Commerce Clause against some of these measures. On the other hand, the federal government has been cautious in using very long-standing powers for all of these requirements. It used the power to regulate safety in the workplace, which is a long-standing power, the power to impose conditions on spending, which falls under a different clause. So that would support upholding this. And it's, again, why I think these aren't the strongest claim, but you need to expect claims that this goes beyond regulating interstate commerce. One thing opponents will raise is that the Supreme Court has struck down the CDC moratorium as going beyond government power. Although they use statutory interpretation, they could also suggest this violates the Commerce Clause, but we can say that these requirements are different than the CDC moratorium. They are using established power and they're directly about preventing disease. But expect Commerce Clause claim. Also expect claims that the spending clause use is coercive. The Medicaid, Medicare funding is also used by public entities. And there's a couple of cases that say you can't use spending to coerce the state. One question is, the spending requirements apply to private actors as well, where this doctrine doesn't apply. So if you're treating private and public entities, is this even relevant? And scholars differ on this. And the other is this really coercive? And you can say removing all your Medicaid and Medicare funding can be coercive to some institutions, can be a live or die issue. We can also expect general federalism claim that this is beyond the power of the federal government. Again, the fact that they're building on long-standing powers should help, but those claims will be raised and there will be controversy about them. Stronger claims are the claim that these measures violate existing statutes. Where these claims are probably stronger is in challenging the use of this for OSHA, which is why I put this here. But remember, although we have a long history of imposing funding conditions on Medicaid and Medicare funding, every case is a new one, and we can expect an argument that this is beyond the use of federal funding, that this goes too much. I don't think it's a strong argument because, again, we have a long history of imposing conditions on Medicare and Medicaid funding. Some of these conditions have already been about preventing infectious disease. On the other hand, it's clear to everyone that this is not just to prevent COVID in the hospitals, although it is that too, but also as part of a general plan to increase vaccine rates, and that may be used to challenge this. Even if it's within the occupational safety and health standards, and I'll say something about that in a moment, there's a challenge. So the president wants to use an emergency temporary standard, and that's a much higher bar. So let's talk a little bit more about OSHA, because I think that's where even scholars that support vaccines are asking, does this make sense? And I will add that we haven't seen the standards yet. We're talking, we have the blurb from the president, but a lot of this is going to depend on the details of the standards, and we don't know that yet. So the Occupational Safety and Health Act allows standards that are reasonably necessary or appropriate to provide safe or healthful employment and places of employment. Listening to this, you can probably make a good claim of a nexus to a vaccine or test requirement in the workplace. However, two things that would push against that is A, it's clear that this is part of a more general plan that isn't focused just on workplace, and the president desires to raise vaccine rates generally. And B, it's not clear that this is more of a risk in the workplace than generally in the community. So that's, if you're wondering why I keep saying what the other side will say, is you need to consider going forward what the arguments will be before we can come up with an answer. So I'm not making the case for, I'm not opposing the requirements, I'm just warning you against what you might hear. Trickier is the use of an emergency standard. The emergency standard allows quick passing of a standard without going through the elaborate procedure you have for to go for a standard generally, but it requires grave danger from substances or agents determined to be toxic or from new hazards. And it has to you have to show that such an emergency standard is necessary, not reasonably necessary, but actually necessary to protect employees. This is vulnerable in a number of ways. And again, it depends on how carefully tailored the standard will be. First, some are saying already, this is not a substance or an agent determined to be toxic, although you can push back and say a virus that destroys cells may fit into at least physically harmful. And this is not a new hazard because the virus has been around for over a year. So there will be a challenge. Is this even appropriate for an emergency standard under the heading of, is this toxic or physically harmful? Is this a substance or an agent that's toxic or physically harmful? And is this a new hazard? More tricky is an emergency standard actually necessary to protect from danger? And there's some questions that are going to come up. If it's a sweeping standard, what about places that are still working from home? Silicon Valley has several companies that are still working from home. Can we say that it's really necessary to protect those employees from danger to impose a vaccinate or test requirement? What about places that aren't working from home, but have very strong safety protocol and extensive PPE? So this may be challenged under statutory interpretation. It may also be challenged under administrative law. If you're wondering about the pictures, they're not related to the text. I had my children choose them because they're pictures. But every administrative law rule has, most of them have to withstand the arbitrary and capricious standard. The arbitrary and capricious standard requires the agency to have reasoned arguments for its choices, and they can't be purely political. So the president wants this isn't good enough. So this will depend on how OSHA reasons the standard, but this is a common challenge because it leaves scope for courts that don't like it to strike it down, saying you didn't think about it through enough. And again, is this within the exception for the standard? This, again, much of this is going to be a challenge to, you can't do this through an emergency standard. You have to go through the full rulemaking, which will take at least a few months. Because we need action now, this can really delay action by the federal government. We'll know better how viable these are when the standards come out, but they will almost certainly be raised. I want to end by saying two things about the California school district mandate, and I'm using mandates here because that's what the school district called it. I want to say three things about them. A, while I expect constitutional challenges to this mandate, I don't think they're going to go very far because we have in California recent cases that upheld school mandates. Where I think the school mandates might be vulnerable is under two other claims. One claim is what we call preemption. Preemption is generally a claim that a lower body of law has to give way to a higher. You can say state law has to give way to federal. And by the way, going back to the federal mandates, one way they may be used is employers in states that have bans on vaccine mandates will probably use them, as was raised in the question here earlier, to challenge the vaccine mandate bans. This is a tool to help some employers challenge vaccine mandate ban. But here, preemption talks about the relationship between local authorities and the state. The state of California has powers, but so do school districts. And the question is how they will interact. The arguments of mandate opponents would be the state already has a comprehensive detailed school immunization law, and therefore, by implication, it's preempting local government from acting on its own, and that will include school district. And California does have a very detailed immunization law. The pushback against this will be school districts in California also have broad power under the legislation. So maybe the legislator is giving them that power, and maybe we shouldn't read their powers more narrowly. These are two arguments that I think each has validity, and I think it's a 50-50 which one the court will think is stronger. This is a realistic claim against the mandate. It may lose in court, it may well lose in court, but it's not frivolous, it's not senseless, it will probably be raised. The other thing we need to be concerned about when it comes to school mandates is the fact that vaccines for 12 to 15 are still only under an emergency use authorization. In spite of the fact that it doesn't sound that way, and in spite of the fact that I really think that you can mandate a vaccine under an EUA, legally it is still an open question. And both sides have arguments, and it's not just the anti-vaccine people. There are serious scholars who think that you cannot mandate a vaccine under an EUA. The people who think you can't mandate it point to language in the law that says that you have the option to accept or refuse the vaccine. That the Secretary of Health and Human Services has to alert you that you have the option to accept or refuse the vaccine. And they point to previous statement that CDC and FDA did make that says you can't mandate an EUA vaccine. And they also say, as a policy matter, these vaccines may have gone through extensive testing, but many EUA products haven't, and we don't want to open the door to mandates for things under an EUA. That's, again, that is not a frivolous concern, and it's not an anti-vaccine concern. If we allow these vaccines to be mandated under an EUA, how would we feel if we go forward and there's a vaccine that's a lot less tested and someone wants to mandate it under an EUA? I know it's tempting to focus on the short-term consequences, but we're going to do immunization hopefully for decades, and we want to not shoot ourselves in the foot now. On the other hand, the reason I think there's a strong argument that you can mandate a vaccine under an EUA is, first of all, the same law that says you have the option to accept or refuse mentions that there may be consequences to refusal. The law doesn't mention private employers or states or schools at all. We at this point have one court decision that says yes, and private employer can mandate vaccine, and an opinion by the Office of Legal Counsel for the President that says you can mandate an EUA vaccine. And although EUA products often may have less data than other vaccines, this is not true for these vaccines. They have extensive testing. Even for teens, at this point, we have millions of teens that receive them. We do have a question about rare cases of myocarditis in teens, but we have strong data that they're substantially safer than COVID. So we're not in the same point as we would be for a very new EUA vaccine. So this is the general legal issues you should keep in mind and new things you need to worry about, since I know you don't have enough to worry about. I'll stop here and let me know if anyone has questions.
Great, thank you. If anybody has any questions, please feel free to raise your hand or put something in the chat. Yes,
I can share the slides afterwards. I'm happy to send them to Jamie or Erika, whichever one you tell me, and who can share them with everybody.
If I could just offer my gratitude to Dorit while we're waiting. Oh, can you hear me well? On my phone is little. I just want to offer our gratitude. I don't know what our world was without Dorit, and I don't know what we would do without you now. So thank you very much. This is so well thought out, and I have a lot of questions, but some of them are just, one of them is, can you give a crystal ball? So if there are these, for all of the different legal battles that we'll be facing for the mandate, do you anticipate that we will potentially be moving forward with a lot of them while the battles are ongoing, or do we have to wait for the battles and all the legal go through first?
I think we can't move on several of them until we see the standards and until we see the lawsuits. I do think we need to move now on the religious exemption issue because it's already being fought out. And the danger is, so some of you may be more or less indifferent to whether healthcare workers in New York and Maine can use a religious exemption. But jurisprudence that says you have to give a religious exemption for a vaccine mandate is going to have very broad impact throughout the United States, especially if it's not carefully tailored to adults. We could end up with a Supreme Court decision that says you have to give a religious exemption from any vaccine mandate, including schools. That's not impossible. I think it's not very likely, but we need to move on the religious issue as soon as we can.
Any other questions?
And thank you everyone for the kind words.
Okay.
There's a question in the chat. Can I read
Yes.
it for you since I know you're busy? It says,
Go ahead.
if this goes down the rulemaking route, if deemed arbitrary, oh my God, my fingers, and capricious, is that, I'm sorry, I have to read it again. If this goes down the rulemaking route, if deemed arbitrary and capricious, is that a process that we can begin while arguments come out?
So generally speaking, what will happen, so this isn't the first rodeo that this went through, but what would happen was, first of all, OSHA would come out with the standards, as will the Centers of Medicaid and Medicare. People are already preparing the lawsuit, so the lawsuit will probably come down shortly after the standard, and a lot of the game is a lot of the more meaningful effect is going to be at the stage of the preliminary injunction or the TRO. Long term, it's really important how the case also ends. But for the COVID-19 pandemic, the critical question would be, would a judge put the measure on hold while this is being litigated? And if the judge puts it on hold, is that going to be local or national? With the Trump measures, we've seen both. We've seen some where judges have put them on hold and the hold was national. Some where the judges put it on hold and initially we may have saw the hold was national, but then the Supreme Court said it's limited. And some where the judges didn't put them on hold. A lot of the battle really is going to be at the stage of what happens immediately because of the timing. Will a judge give a temporary restraining order or preliminary injunction? There is one case. There are a couple of cases where where Catholics have been denied. It's tricky, and it's probably going to be struck down if it goes higher, because the standard isn't what the Pope said. The standard is a personal belief. Catholics can and have used religious exemptions even when the Pope supported vaccines. Not all courts will go there. Some courts are saying, we just don't believe you. We think you're lying if you're saying that, if you're a practicing Catholic and you're going against the Pope, we just don't believe you. But there's at least a chance higher court will overturn that and say the standard is personal sincerity, and we're not sure we accept it. We'll see. If the COVID-19 is approved for a 12 to 15-year-old, licensed for 12 to 15-year-old, the UA argument will go away. Note that anti-vaccine activists are trying to get around that by saying the old stock that doesn't have the new label of the licensed vaccine is still unlicensed. I don't think the court will accept that, but they're trying. There's a question, is a requirement for business to adopt a test or a vaccinate requirement really a mandate? And I think that's a good question, because so there's two answers to this. First of all, I would define mandate as vaccinate or face a consequence. So to remind you, before COVID, when we had flu mandates, many of the mandates was vaccinate or mask. It's not always vaccinate or fire, and they were still a mandate. Second, mandate is a charged word, and for communication purposes, we may want to work hard on changing that language and saying this is not actually a mandate, and I obviously have not internalized that, so I should probably work on myself as well. This is not actually a mandate. This is a vaccinate or test work safety plan, or someone who's better at this can come up with better language. So we may actually really want to change that language, but the legal assessment will still be the same. It will be, is this reasonable under Jacobson, and is this within OSHA's power to pass an emergency status? We do want to change the language. If anyone can come up with really good language, please. That's, yeah. I should know this about the, so a question in the chat is does the Biden plan include time off for reactions? And I should know that because I've read it, and I really like the part about providing leave. But let me just open it and see.
Yeah, and it would be interesting to know if that applies to parents. If you're taking your child to get vaccinated and they have a reaction and you need to stay at home with them.
Yes, it says that this includes.
I know it too. I just didn't have time to.
Yeah, it says. Yeah, it says provide pay time off for the time it takes to get vaccinated or to recover if they're under the weather post-vaccination. So it's both.
Perfect.
Great. And does that apply to parents too, if you need to stay home with a sick 12-year-old, or does it not?
I'd like. So let's see what OSHA actually says. It doesn't say one way or the other here, but this is something that if they don't put in the proposed rule, we should put in the comments and point out that it should. Yeah.
Great. Well, thank you guys so much. Thank you, Dorit. This was really, really interesting, really helpful. And we appreciate you so much.
Thanks for listening.